Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover 4 fundamental questions in the series, and today we are talking about the 4th one, which is holding interest in property. The most common way to own property is through one of 3 primary types of freehold estates: the fee simple absolute, the life estate, and the defeasible fees. In this video, we discuss the defeasible fees. First, let's say what defeasible means. It means capable of being annulled or voided. A defeasible fee is one which may be taken away if a condition occurs or if an action is taken. These defeasible fees include both current interest, present possessory interests, and future interests, which are pre-possessory. Defeasible fees differ from defeasible remainders discussed in another video, the video about life estates, because defeasible fees are present possessory interests, while defeasible remainders are future interests. There are 3 defeasible fees, which we will focus on today: the fee simple determinable, the fee simple subject to conditions subsequent, and the fee simple subject to executory limitation. The first kind of defeasible fee, the fee simple determinable, is an estate that will automatically end and revert to the grantor if some event occurs. So you would look for words like as long as, or during, or until. A fee simple determinable occurs, for example, when O grants property to A as long as the property is used for charitable purposes, or another example, to A while A is using the property as a law school, then back to O. You don't need that phrase, then back to O, for an interest to be created in O. While A owns the property, O has a future interest called the possibility of reverter. If the condition occurs, the property goes straight back to the grantor, goes back to O or O's heirs if O has died. So the second kind of defeasible fee, the fee simple subject to conditions subsequent, is an estate subject to the grantor's power to end the estate if a condition occurs, but the grantor has to act to exercise this power. So this kind of defeasible fee might arise, for example, when O grants property to A unless A consumes alcohol on the premises, in which case O may re-enter and take the property. So O can exercise this right by bringing an action for ouster, or can physically re-enter the property subject to any legal limitations on self-help. If the condition occurs, the property can go back to the grantor, but once again, differentiating it from fee simple determinable, this is not automatic. O has to actually act to obtain the property. So the first 2 kinds of defeasible fees have assume that there are future interests in the grantor. The third kind of defeasible fee, the fee simple subject to an executory limitation, is an estate that is subject to divestment in favor of someone other than a grantor if a specific event occurs. In other words, the future interest is held by a third party who is not the grantor. One kind of executory interest is a springing executory interest, which divests the interest in the original grantor. So an example of this. All right, so O grants the property to A for life, and then B gets the property 5 years after A dies. So O gets the property, gives the property to A for life, and then to B 5 years after A dies. So you can see right off the bat, there is a 5-year gap in this scenario. So in the scenario, A has a life estate. O has a reversion for 5 years. If you don't remember what that is, go back to the video on life estates. O, meanwhile, gets the property it gets the property for those 5 years, but because of the condition which would allow the property to be transferred to a third party, it's held in fee simple subject to executory limitation. B, therefore, has a springing executory interest because B's interest springs from O's estate 5 years after A has died. So now consider O granting the property to A for life, then to B, but if B fails to graduate from college by age 25, to C. In this scenario, different from the last, A still has a life estate. B has a remainder, which is not indefeasibly vested. It is subject to complete divestment, meaning it can be completely taken away. When B's remainder becomes a present interest, it is a fee simple subject to condition subsequent. It is a fee simple subject to executory limitation. Long day. C has a shifting executory interest, which will result in C having the property in fee simple if B fails to graduate from college by age 25. All right, so it's important to clarify something here with respect to remainders. You might think that the shifting executory interest would be a remainder, a future interest arising in a third person who is intended to take after the natural termination of the preceding life estate. But remember that remainder language is to A for life, then to B. An executory interest is any future interest created in a person other than the original grantor, which is not a remainder. So if it's going to a third party and you're not dealing with a life estate, chances are it is a shifting executory interest. So in summary, when you come across an estate in land where there are certain conditions on fee ownership, then the interest is probably defeasible. Your primary question then should be, who gets the estate after the present interest holder? If it might go back to the grantor, it's probably a fee simple determinable or a fee simple subject to condition subsequent. If it might go back to a third party, then it's probably a fee simple subject to an executory limitation. So defeasible fees, they're always future interests. You always have to match a defeasible fee with the right future interest with accurate names. So the possibility of reverter, the right of entry, and the executory interest, whether springing or shifting. You must also try to figure out what happens when those future interests become present interests. Is it a fee simple absolute, or as in our last example, a fee simple subject to executory limitation? So with that very dense, packed conversation about defeasible fees, I will leave you there. I would love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.